All right, here we go. Hi, everybody. I'm Teresa Reed. Welcome. I'm a member of the Brews and Views Committee of the Ann Arbor Area League of Women Voters, serving all of Washtenaw County. This is our third of 3 monthly Brews and Views on the topic of our voting systems. Some of you remember that in April, we talked with Professor J. Alex Halderman about election security. Last month, we talked with Michigan Director of Elections, Jonathan Brader, about the implementation of the constitutional changes to Michigan's voting laws that we all passed in Prop 3 in 2018. This month, we're addressing the Electoral College. The framers of the US Constitution established the Electoral College for several reasons that seemed to serve certain purposes at the time. But this abstruse system has deprived the majority of Americans their choice for president 5 times in American history, 3 in the 19th century, and 2 in the last 20 years. In 2000, Vice President Al Gore won the popular vote against Governor George W. Bush by more than 500,000 votes, but lost in the Electoral College by 1 vote after the US Supreme Court intervened. In 2016, Hillary Clinton won the popular vote by nearly 3 million votes, but lost the Electoral College by 78,000 votes in 3 states. In 2020, Joe Biden won the popular vote by well over 7 million, but barely eked out a victory in the Electoral College. Many commentators have warned that the Americans' faith in the legitimacy of our election and democracy can't withstand many more presidential elections in which the candidate who wins millions more popular votes does not win the presidency. But what can we do? More than 700 attempts to reform or abolish the Electoral College line the dustbin of history. Is it within our power to abolish the Electoral College and secure the promise of 1 person, 1 vote for the highest office in the land? If it's not within our power, what perils does our democracy face, and how do we prepare for them? Our speaker tonight, Maria Woloson, is an attorney with decades of experience in personal injury litigation and probate and estate planning. She's a member of the board of directors of the League of Women Voters of Oakland County and serves on the advocacy committee of Michigan's statewide League of Women Voters. As an active league member, Ms. Woloson has participated in voter registration drives, candidate forums, and educational programs. Her unofficial motto is, "Democracy is not a spectator sport." Maria, welcome. We're so glad to have you here. Thank you for being here.
Right. Thank you very much, Teresa, for that introduction. And in fact, Teresa, you just gave so much information about the Electoral College. I feel like, oh, well, maybe my job is done, but.
Hardly.
Oh, well, beautiful scene here. There we go. All right. As indicated, we are the League of Women Voters, nonpartisan political organization that encourages informed and active participation in government. So I'd like to start by basically giving you a little bit of background information about the United States Electoral College. And I guess I want to start out by saying is that I'm not a constitutional lawyer by any means. I probably took 1 class of constitutional law about 100 years ago when I was in school, but and all of this information is in the public domain. So I'm not divulging any secrets here, and it's all out there. So I'd like to start out by basically just giving you a little bit of background and history. The United States Electoral College is the group of presidential electors required by the Constitution to form every 4 years for the sole purpose of electing the US president and vice president. Each state appoints electors according to its legislature, equal in number to its US congressional delegation, that would be the senators and representatives. Federal office holders cannot be electors. Of the 538 electors, an absolute majority of 270 or more electoral votes is required to elect the president and vice president. If no candidate achieves an absolute majority there, a contingent election is held by the United States House of Representatives to elect the president and the United States Senate to elect the vice president. And I'll talk about that, what happens with that a little bit later in the talk. Currently, the 50 states and the District of Columbia hold a statewide or district-wide popular vote on election day in November to choose electors based upon how they have pledged to vote for president and vice president, with some state laws against faithless electors. And I'll talk about that in a little bit later. All jurisdictions use a winner-take-all method to choose their electors, except for Maine and Nebraska, which choose one elector per congressional district and 2 electors for the ticket with the highest statewide vote. The electors meet and vote in December, and the inauguration of the president and vice president takes place in January. Now, the Electoral College is a result of a series of compromises struck during the grueling and very hot Constitutional Convention of 1787. Delegates argued over numerous ways to elect a president. Some believed citizens should vote directly, while others argued that Congress should decide. Others insisted that this would give the national legislative body too much power and that the decision should lie with the states. Giving states electoral power also raised the question of how less popular states would be represented. And this was a big sticking point with the southern slaveholding states, which lacked the population of their northern neighbors. Delegates from those states insisted that their enslaved residents, who were not considered citizens and would not be allowed to vote, be counted for the purpose of allocating electoral votes. Finally, the framers agreed on the following method. Article 2 of the Constitution indicates that each state would appoint electors equal to the number of its US senators and representatives. While the size of the House of Representatives would be based on population, as determined by the US Census, each state received 2 senators to give a small bump in power to the less popular states. The question of how to count enslaved people resulted in the notorious 3/5 compromise, which determined that 3 out of every 5 slaves would be counted as persons for congressional representation, taxation, and the Electoral College. The 14th Amendment in 1868 explicitly repealed the 3/5 compromise. It provided that representatives shall be apportioned, counting the whole number of persons in each state, excluding the Indians who were not taxed. But then, as a side note, Native American tribes were granted US citizenship in 1924. The former slave states subverted the objective of the 14th Amendment changes by using various strategies to disenfranchise Black voters while obtaining the benefit of apportionment of representatives on the basis of the total population. Their power allowed them to defeat federal legislation against racial inequity and abuses in the South until overcome by the civil rights movement in the 1960s. And I would just like to say voter disenfranchisement and the Native Americans are only mentioned here very briefly, as they are very, very complicated issues well beyond the scope of this presentation. Since 1880, electors in every state have been chosen by a popular election held on election day. The popular election for the electors means the president and vice president are in effect chosen through indirect election by the citizens. Since the mid-19th century, when all electors have been popularly chosen, the Electoral College has elected the candidate who received the most, though not necessarily a majority, popular votes nationwide, except in the elections of 1876, 1888, 2000, and 2016. Just as a side note, in 1824, when there were 6 states in which electors were legislatively appointed rather than popularly elected, the true national popular vote is uncertain. But basically, the electors in 1824 failed to select a winning candidate, so the matter was decided by the House of Representatives. Looks like you already have the next slide up. Thank you. A state's number of electors equals the number of representatives plus 2 electors for the senators the state has in the US Congress. The number of representatives is based on the respective populations determined every 10 years by the US Census, which is why the league was so involved with trying to make sure as many people as possible were counted in the census. Based on the 2010 census, each representative represented an average of 711,000 individuals. Under the 23rd Amendment, Washington, D.C. is allocated as many electors as it would have if it were a state, but no more electors than the least popular state, which is 3. Currently, there are 538 electors, 435 representatives, 100 senators from the 50 states, and 3 electors from Washington, D.C. Faithless electors is one who does not cast an electoral vote for the candidate of the party for whom that elector pledged to vote. 33 states plus the District of Columbia have laws against faithless electors. Faithless electors have never changed the outcome of the US election for president. Altogether, over 23,000 electors have taken part in the Electoral College as of 2016. And only 165, that's like 1.5%, have cast their votes for someone other than their party's nominees. And now I just want to mention very quickly about the US territories. US territories are not entitled to electors in presidential elections. Constitutionally, only US states and the District of Columbia are entitled to electors. As a result of this restriction, roughly 4 million Americans in Puerto Rico, Northern Mariana Islands, US Virgin Islands, American Samoa, and Guam do not have a vote in presidential elections. Now, I will say that Guam has held non-binding straw polls for president since the 1980s to draw attention to this issue. The Democratic and Republican parties, as well as some other third parties, however, have made it possible for people in US territories to vote in the party presidential primaries. That's a lot of P's there. Anyways, can I have the next slide, please? Thank you. Now let's talk about the procedure for counting the Electoral College votes. The 12th Amendment mandates that Congress assemble in joint session to count the electoral votes and declare the winners of the election. This session is ordinarily required to take place on January 6th in the calendar year immediately following the presidential election. The newly elected joint Congress declares the winner of the election. All elections before 1936 were determined by the outgoing House. The Office of Federal Register is charged with administering the Electoral College. The meeting is held at 1 p.m. in the chamber of the U.S. House of Representatives. The sitting vice president is expected to preside, but in several cases, the president pro tempore of the Senate has chaired the proceedings. Boxes containing each state's certified vote are brought into the chamber. Each house appoints 2 tellers to count, normally 1 from each political party. Relevant portions of the certificate of vote are read for each state in alphabetical order. Members of Congress can object to any state's vote count, provided the objection is supported by at least 1 senator and 1 representative. The vote count is stopped, the joint session is suspended. The Senate and House of Representatives meet separately to debate and then vote on the objection. A state's certificate of vote can be rejected only if both houses of Congress vote to accept the objection via a simple majority, meaning the votes from the state in question are not counted. If there are no objections or all objections are overruled, the presiding officer simply includes a state's votes as declared in the certificate of the vote in official tally. As the certificates from all states are read and the respective votes are counted, the presiding officer simply announces the final state of the vote. This announcement concludes the joint session and formalizes the recognition of the president-elect and the vice president-elect. The final tally is printed in the Senate and House journals. If I can have the next slide, please. And hello. Thank you. I just want to talk real briefly now about what actually happened on January 6th, 2021. At that time, at 1 p.m., a joint session of Congress began with reading the results from each state, one at a time, in alphabetical order. The results of Alabama and Alaska were read without objection. The results of Arizona were objected to by US Representative Paul Gosar of Arizona and US Senator Ted Cruz of Texas. Because of the objection, the joint session adjourned at 1:15 p.m. to allow each chamber to debate and vote on the objection. During the debate of Arizona's votes, a crowd of over 20,000 people forced its way into the US Capitol at about 2:15 p.m., disrupting the proceedings. Members of the House of Representatives and Senate were evacuated from the Capitol chambers. Congress was placed under lockdown. The District of Columbia National Guard, as well as National Guards and state police of the neighboring states of Virginia and Maryland were activated. At approximately 5:40 p.m., the Sergeant at Arms announced that the Capitol building had been secured. Congress then reconvened at 8 p.m. The debates resumed regarding the objection to the Arizona electoral votes. The Senate then voted to reject the objection by 6 to 93 at 10 p.m. and was followed by the House rejection by 121 to 303 at 11 p.m. The joint session resumed again shortly afterwards. The state counts proceeded alphabetically until Pennsylvania's electoral count was objected to by US Representative Scott Perry of Pennsylvania and US Senator Josh Hawley of Missouri. The joint session was again adjourned at 12:15 a.m. The Senate rejected the objection by 7 to 92 vote. The House rejected the objection at 3 a.m. by 138 to 282. The joint session resumed again at 3:25 a.m. with the tallying of the results. At 3:33 a.m., the electoral votes of Vermont were counted, putting Biden and Harris ticket over the 270 electoral votes needed to secure the presidency and vice presidency. After declaring the Biden-Harris ticket winners of the election, the joint session was dissolved at 3:44 a.m. on January 7, 2021. There have been several how shall I say, theories about why there was this disruption in the counting of the Electoral College votes. And it may be because of this next slide on the US House of Representatives. If no candidate for president receives an absolute majority of the electoral votes, and that would be 270 of the 538, then the 12th Amendment requires the House of Representatives to go into session immediately to choose a president. In this event, the House of Representatives is limited to choosing from among the candidates who receive the most electoral votes for president. Each state delegation votes in block, meaning each delegation has one vote. The District of Columbia does not get to vote. A candidate must receive an absolute majority of state delegation votes, and that would be a minimum of 26 votes, in order for that candidate to become the president-elect. Additionally, delegates from at least 2/3 of all states must be present for voting to take place. The House continues balloting until it elects a president. The House of Representatives has been required to choose the president only twice, in 1801 and in 1825. Now, can I have the next slide, please? All right, I want to give you some examples of what has happened recently with the Electoral College. First, I want to talk about in 1972, Richard Nixon won 61% of the popular vote, while George McGovern won 38%. The Electoral College votes, however, were distributed 520 to Nixon and 17 to McGovern. This resulted in 96% of the Electoral College votes to Nixon and only 3% to McGovern. The diagram that's up on the monitor right now talks about what happened in 1984. Ronald Reagan won 59% of the popular vote, while Walter Mondale won 41%. The Electoral College votes, however, were distributed 525 to Reagan and 13 to Mondale. This resulted in 97% of the Electoral College votes to Reagan and only 2% of the Electoral College votes to Mondale. The elections of 1876, 1888, 2000, and 2016 produced an Electoral College winner who did not win the nationwide popular vote. In 1824, there were 6 states in which electors were legislatively appointed rather than popularly elected. So it is uncertain that the national popular vote would have been if all presidential electors had been popularly elected. If I could have the next slide, please. Oh, thank you. Now, changing the election process for the US president and vice president. The appropriateness of the Electoral College system is a matter of ongoing debate. Supporters argue that it is a fundamental component of American federalism by preserving the constitutional role of the states in presidential elections. Critics argue that the Electoral College system is less democratic than a direct popular vote, and that the college violates the democratic principle of one person, one vote. Thus, a president may be elected who did not win the national popular vote, as occurred 5 times in recent history. And Teresa already mentioned this, but I'm just very surprised by this. Since 1800, over 700 proposals to reform or eliminate the system have been introduced in Congress. Proponents of these proposals argue that the Electoral College system does not provide for direct democratic election, affords less popular states an advantage, and allows a candidate to win the presidency without winning the most votes. None of the proposals have received the approval of 2/3 of Congress and 3/4 of the states, which is required to amend the Constitution. I wish to talk briefly now about what has been talked about, the National Popular Vote Interstate Compact. As of July 2020, 15 states plus the District of Columbia have joined the National Popular Vote Interstate Compact. Those joining the compact will, acting together if and when reflecting a majority of the electors, now that would be 270, pledge their electors to the winner of the national popular vote. The compact applies Article 2, Section 1, Clause 2 of the Constitution, which gives each state legislature the plenary power to determine how it chooses electors. Now, some scholars have suggested that Article 1, Section 10, Clause 3 of the Constitution requires congressional consent before the compact could be enforceable. Thus, any attempted implementation of the compact without congressional consent could face court challenges to its constitutionalities. Others have suggested that the compact's legalities has already been strengthened by the case of Chiafalo versus Washington, in which the Supreme Court upheld the power of states to enforce electors' pledges. Presently, electors of 16 adherents to the compact number 196, which is 73% of the 270 required for it to take effect or be considered justiciable. Now I would just like to read the brief statement by the League of Women Voters, US, and their position regarding the Electoral College, and that is as follows. The League's position statement of position on selection of the president as announced by the National Board, January 1970, revised 1982, updated 2004, and revised by 2010 convention. The League of Women Voters of the United States believes that the direct popular vote method for electing the president and vice president is essential to representative government. The League of Women Voters believes, therefore, that the Electoral College should be abolished. The League does support the use of the National Popular Vote Interstate Compact as one acceptable way to achieve the goal of the direct popular vote for election of the president until the abolition of the Electoral College is accomplished. That is basically the presentation. And I think I have one more slide here. How about, oh, and this basically says that constitutional amendments do happen. They do happen. And I believe I have one more slide that shows, thank you. These are all the amendments that have been approved since the beginning of the United States of America. And people have said it is a monumental task, but it has happened. It has happened. So with that, I will turn the presentation. Oh, and don't you love that picture? I love that one. I'll turning the presentation back to you, Teresa. Thank you.
Okay, great. Thank you very much. It's not just back to me, it's back to Q&A, so you're still on.
Oh,
you're the expert. So we have 3 questions that came in before the talk. One is that the New York Times editorial board recommended amending the law governing counting the electoral vote. What changes do you think could improve that process?
I'm you know, I've looked at this a lot, and well, let me put that in perspective. I've done some reading about it, and it is such a complicated issue. I am, you know, I've seen opinions kind of all over the map, but and I don't have an easy answer. I just don't.
Okay. It is really incredibly complicated. I mean, as I said in the intro, some 700 attempts to reform or abolish the Electoral College have failed over the course of our history. So efforts have been made. So can you speak a little bit more about the Interstate Compact? You had circulated an opinion from, I think it was Harvard Law Review, or it was an article out of Harvard about the constitutional problems with it, potential constitutional problems with the Interstate Compact,
Right.
and the fact that the incentives are entirely right now for blue states to pass the contract and red dominated states to not pass the compact because the incentives don't line up.
Right.
Can you speak to that at all about the constitutionality of it and the pragmatics of potentially passing it? Let's start with the pragmatics of potentially passing it.
You know, again, the way the politics are right now in this country, it's very discouraging. I mean, you just have these two separate camps and they're just fighting one another. They're not, it's a war. Like they don't want to compromise. And that's why the way things are right now, I just think we're in a stalemate. I just, and it's very discouraging. It's very discouraging.
So because with the Electoral College and the apportionment of 2 senators to every state, probably everybody in this meeting understands, North Dakota has as many senators as California. And so in that, obviously affects the electoral vote power. And to imagine that, and those are typically strongly red states. So to imagine that they would give up that power willingly is kind of naive. So do you know how many states have accepted or passed the law accepting the Interstate Compact?
I think I saw that.
I think we're at about maybe 180.
Yeah.
And about as high as we are going to be able to go.
Yeah, I believe it was I can't remember what exactly the number is, but it's basically as difficult and a proposition to get the Interstate Compact passed as it is to amend the Constitution. And it seems that the Interstate Compact can be overturned at any time and by a state I believe all they have to do is give 6 months notice before the next election. Whereas, and to spend all of those resources, because it will cost millions of dollars. Many groups will have to join in the effort to get either the Interstate Compact passed or the Constitution Amendment passed. So it's a matter of where do you put your resources?
Yeah, strategically, the Interstate Compact, otherwise known as the National Popular Vote Initiative, it may just not be worth it. Yeah, well, that's a good point. So maybe the constitutional amendment just makes more sense. It's more permanent. It's a more permanent victory.
Absolutely.
Yeah. Tough.
But what I do believe, national opinion, the popular opinion is that what is this Electoral College? And in fact, most people, when it comes around every 4 years, they go, oh, what's this Electoral College about? And then everybody forgets about it until they're not. But so to me, but overwhelmingly, people who learn about it, they go, what is this about?
Yeah, it's really interesting. I mean, it's so complicated. Even if we learned about it in grade school or even high school, it's still hard. It's so, it's hard to parse because it doesn't really, it's like we think we're voting for president, but in fact, we're voting for electors. Yeah. And it's just right. I think it doesn't stick because it's so illogical.
And as far as I know, there's no other country in the world who does this.
Yeah, right.
No other country. If anybody knows one, please tell me.
Yeah, right. It's a really strange artifact of the state of the states at the time of the Constitutional Convention. And that is to say, in fact, just frankly, the existence of slavery. So yeah, our original sin. Somebody asked this, with many states considering or even passing legislation that will allow legislatures to overturn the results of a presidential election, what are the implications for a national popular vote initiative?
I think it's very scary. I think it's scary that a minority group, I don't care who they are, can do that.
Yeah.
I think is very scary.
And I think that that question has really been answered already by your comments about the fact that any state at any time, even if they've joined the NPV, you know, one legislature has joined it, the next legislature can unjoin it.
Exactly.
So it's very unstable anyway. Let me see what's in chat here. Craig Harvey writes that, oh, thank you, Craig. As of April 26, 2021, the bill has been enacted into law in 16 jurisdictions, possessing 195 electoral votes, including 4 small states, Delaware, Hawaii, Rhode Island, Vermont, 8 medium-sized states, Colorado, Connecticut, Maryland, Massachusetts, New Jersey, New Mexico, Oregon, Washington, and 3 big states, California, Illinois, New York, as well as the District of Columbia. Somebody asked, Susan asked, what's Michigan's status? I had thought Michigan had joined a while ago, but apparently not.
No.
Yeah.
It was brought up a number of years ago in the Michigan State Legislature, and it didn't go anywhere.
Nowhere. So Susan thought it had passed the House.
No.
It didn't pass the Michigan House. Okay.
And I don't know, but it is, Michigan is not part of the interstate.
Yeah. Okay. Okay. Jane asks, I haven't read this, so here, I'm just reading Jane's words here. If each state individually decided to split their electoral college vote in accordance with the overall state vote instead of winner take all, how close would that come to approaching a solution to the problem? So you understand that question. So right now, most states, you know, if Biden gets 51% of the vote in Michigan and an opponent gets 49%, Biden still gets all of the electoral votes of the state.
Right.
I know some people have talked about this, right? In some states, I think, do split electoral votes according to the popular vote. Is that correct? And what do you know about that? What can you tell us about that?
You know, all I know is that I believe there's 2 states that Maine and Nebraska. They choose 1 elector per congressional district and 2 electors for the ticket with the highest statewide vote. Those are the 2 that I know of.
Okay, so we don't know of anybody that splits it according to the winner of the popular vote.
Yeah.
Okay. Craig, thank you for the link. Everybody, there's a link on the National Popular Vote Initiative in chat right now. Someone asked what the rationale was for establishing the Electoral College. Do you want to speak to that?
Well, you know, as I said, basically back in the old days, you know, in the 1700s, when this thing first came around, it was basically a compromise when the delegates were arguing over whether or not the popular vote should elect the president or the Congress. And remember, these were the days before the internet and electricity. And sometimes it would take like 6 months to have mail go back and forth. That's, and basically the number of reasons for the Electoral College when it was created back in the 1700s are just not applicable anymore. So it's just, I mean, we'll see with all the things that are going on in today's day and age, the voter suppression, the redistricting commission, all of the issues that are going on. It's sometimes very difficult to think, you know, to apply efforts and finances to this really important mission, but it is important. And I just feel that, you know, you have to play the long game on this one.
Yeah, no quick fixes here. Linda says that with the gerrymandering currently in force, assigning by districts would disadvantage one party, especially. So, meaning that if I'm following this, it's that the state is gerrymandered in such a way that a certain party wins the majority of seats in the legislature, no matter what the popular vote is. And so if we based electoral votes on a gerrymandered state vote count, that would be disempowering to the party that has been gerrymandered out of power. I think that's what Linda means, and correct. And Linda, if I got it wrong, throw something back in the chat. John, again, so again, what were the original arguments for an electoral college?
Again, it was a compromise. It was a compromise between the people who wanted the states to have complete control over who was going to be president versus the federal government. And in fact, you know, if anybody wants to read, this is Federalist Papers by Alexander Hamilton back in the 1700s. And now I actually tried to read this, and all I can say is that if anybody has problems with insomnia, this is the book for you, because it just it just went on and on and on about different issues, and that is my understanding is so one of the reasons the Electoral College was created.
So it was, my understanding was that it was a compromise. It was a compromise between giving, I mean, people worried about mob rule, right? The founders worried about mob rule, but they didn't want to give all the power to states, or, you know, to the states, state senators, I mean, to elected persons in the state. So they they intervened between the people and the states who otherwise might appoint a president, I think. Yeah, but I'm not an expert.
Again, you know, I've been reading I've tried to read about why did this system get created?
Yeah.
And, you know, who knows, you know, the politics of the day are like the politics of what's going on right now. You know, do you have an inside ear as to what's going on?
Yeah. So Rena says, yeah, some founding fathers didn't really want the great unwashed populace to choose the US executive. And that's exactly it. I mean, as we all know, you know, originally only landed white men could vote. So it was trying to control the trying to control the influence of the populace.
Yeah, you had to be a landowner.
Yep.
Male.
Right. White.
Yeah.
Right. Right.
Yeah.
I mean, as we know, it's awfully hard to get rid of the filibuster, and that's not even in the Constitution. It's just a relatively recent rule. Okay. All right. If there are no more questions, are there any other questions or anything that you want to discuss? Maria or anybody else? Going? Okay. Well, thanks for joining us for Brews and Views, and thanks again to our intrepid tech hosts, Nancy Brucken, Christine Buffington, and Susan Woolley.
Good job.
Yeah. Next month, we begin our quarterly series on criminal justice reform and restorative justice in Washtenaw County. On July 14th, we'll be joined by Belinda Doolin, who's the executive director of the county's Dispute Resolution Center, and Victoria Burton Harris, chief assistant prosecutor for Washtenaw County. They are both amazing women. I cannot wait to talk to them. We also are excited to bring you a special Brews and Views on June 30th on the power and tenacity of Black women across history, with the author of the book, She Took Justice, The Black Woman, Law, and Power from 1619 to 1969. Professor Gloria Brown Marshall will join us. This special event is offered on June 30th in commemoration of the signing of the US Declaration of Independence, in recognition of both the power and the limitations of that document, which we have explored in some part tonight, and in honor of the dramatically underappreciated contributions of Black women to the women's suffrage movement in the US. We hope you'll join us for that. Look for details via email and on our website, lwvanarbor.org, or on our Facebook page, facebook.com/LWV / LWVAAA. We look forward to seeing you on June 30th. Thank you for being here tonight and take good care.
Thank you. Thank you.
Bye, everybody.